Anything? You're all set? Okay. All right, then let's go back on the record. The record will reflect the presence of all jurors. All counsel are present. The defendant is present. All right, Mr. Owens, would you like to continue?
Yes, thank you, Your Honor.
All right, go ahead.
So here we are on June 14th. Think of what happened in the spring of 2018. Think of what the defendant had already done. Think of what law enforcement already knew. Think about the fact that he was now being brought to justice in a courtroom in San Diego, Vista, San Diego County, and he was going to have to face his accusers. But it didn't stop there, did it? The defendant continued to commit sexually deviant crimes. Think about that and what that means for the why he did what he did. Let's talk a little bit about June 14th of 2018, because on that day, as you heard, there was some highly publicized police action. There was a search warrant that took place at his residence, as you can see. That during the course of that search warrant, they seized numerous items that we talked about already. That the same day his vehicle was seized, you heard about how the GPS tracker had been placed on his Hummer in order to make sure that they could detect his whereabouts. That there was an ongoing surveillance operation to ensure that Mr. Winslow was being monitored by law enforcement. That there was a poll cam monitoring the comings and goings from his residence. And on the 14th, that's when they seized the vehicle and collected the vast majority of the evidence in this case. Now, there was a DNA search done. You had crime scene specialists and you had criminalists, both, who basically tore that car apart, did what they could to at least find what was going to be detectable there. Recall the testimony from Kelly Hensley, the criminalist from the lab. She told you about DNA. She told you about the various forms that it comes in: bodily fluid, potentially blood, potentially semen, right? She talked about sweat. She talked about saliva. Then she talked about touch DNA, right? When you have a leather interior car, you might not be able to get blood in the leather interior, right? When you have the criminalists that are searching for blood, they might not be able to find it. And ladies and gentlemen, you heard the testimony of Jane Doe 1, and she described profuse bleeding, we'll call it that, right? Does that really matter whether there was profuse bleeding or not? Does that really matter to confirm or corroborate what she said when you have the mountain of evidence that I've been discussing now for the last hour and a half? I submit to you, no. It's really not all that different from not being able to have any findings from strangulation, which we know to happen in more than 50% of cases. But what did they find during the DNA search? They found the defendant's semen, a sperm fraction from the defendant, left behind in the back seat of the car. What does that show? It shows that the defendant at least ejaculated at some point in the rear portion of his vehicle along the floorboard, right? We have a defendant who's been accused of sexually violent, forcible crimes. We have the defendant who exposed himself to a neighbor down the street. And we have the defendant who later engages in an act of masturbation in a jacuzzi in public right next to a woman, a 77-year-old woman. What does that show? Is that evidence of his propensity, his predisposition, his sexual perversion? And after the well-publicized arraignment of the defendant, Jane Doe 4 came forward. Jane Doe 4 from across the country, a mother of two, a Marine wife. No interest in the outcome of this case other than to get justice. What she thought would be something that might help Jane Doe's 1 and 2, for all she knew. That when she read in a news account that they may try to use his professional football career as an excuse for what he had done to these women, that shocked and offended her and put her right back into that traumatized state that she had worked so hard to get away from. That she too knew what this defendant was capable of. That she too had something taken from her, just like Jane Doe 1 and 2, and that compelled her to come forward. She didn't make it up on June 18th when she reached out to Nikki. And you know that from the other witnesses who testified. Well before Mr. Winslow had been accused of any other sexual offense, Jane Doe 4 had already told her story. Not one, but two, well, not two, but three people. The three people that she would confide in. Her best friend, her live-in boyfriend, and her husband. And she didn't make some grandiose statement about all the things that he had done to them, that he had done to her. She just told them the truth. She was 17, she had too many beers, she woke up and he was having sex with her, their face being shoved into the crotch of another man. Rape. I'll talk to you about the elements of rape. Forcible rape can occur even when it begins as a rape of an unconscious person. The rape can be done by force or fear even when it initially started as a rape of an unconscious person. And think about that. When the defendant acted, was the victim consenting to the intercourse for the forcible rape? No. The direct testimony is that she was not, that she did not consent to what he had done. Despite the attempts to imply by Mr. Carlos that, well, maybe you must have done something to make him think that he was allowed to have sex with you, she said no. I have no waking memory. My last memory is being on the couch, and my next memory is being raped from behind with my face being pushed into the crotch of another man. And that when she came to, she did try to resist. All 5 foot and 95 pounds of her, with the defendant on top of her, grabbing her, thrusting inside of her, she tried to resist, and she pushed back, and she cried out, and said no, and said stop, and he didn't. That's a forcible rape. She was afraid, she was tearful, she was distraught. Ladies and gentlemen, just because she doesn't have any waking memory prior to the force used, the non-consensual act that occurred, that does not mean that he's not guilty of rape. There's no evidence whatsoever that Jane Doe 4 ever consented to rape, that she ever consented to the defendant's forced sex acts. Let's talk about rape of an unconscious woman, because it does have different elements. The act itself is the same, sexual intercourse with the victim, and that the victim and the defendant were not married to each other, again, not in dispute. But here, there's no consent element for rape of an unconscious person. Consent is not an element of rape of an unconscious person. The third element here is that the victim was unable to resist because she was unconscious of the nature of the act. She was not aware of what was happening. She had 3 beers, she was tiny, she was tired, she was feeling buzzed, dazed. She even described how she was splashing water on her face trying to come to as best she could. And while she did that, what does the defendant do? He's banging on the door telling her to hurry up. What was he planning to do? That her last waking memory is being on that couch, and then she's being penetrated from behind by the defendant. She has given you direct evidence that she was unconscious of the nature of the act. Lastly, the last element is that the defendant knew that the victim was unable to resist because she was unconscious of the nature of the act. Right? Of course he knew that she was unable to resist. How did he get her upstairs? How did he get her into that bed? How did he get her face into crotch of Matt Vaughn? He knew that she was unconscious of what was happening, that she was not aware, knowing, voluntarily acting. A woman is unconscious of the nature of the act if she is unconscious or asleep or not aware that the act is occurring. And that's the evidence that's been provided, and there's been nothing to contest that, right? So then the defendant is guilty of rape of an unconscious woman. He's also guilty of forcible rape of that same woman because when she regained consciousness, she fought back and he continued to rape her. And he turned her and changed the position and raped her further. The defendant is guilty of both crimes against Jane Doe 4. And how do we know that Jane Doe 4 isn't some Johnny-come-lately coming in at the end of things trying to make this all up? Well, you heard the actual evidence of the conversation that took place, and it was caught in real time, because in the digital age, we have a track record of the information that's shared between Jane Doe 4 and Nicole Edwards. And the first thing she says to Jane Doe 4 when she sends her that link to the article that caused her that shock and that harm and that trauma that she had to relive was, "Never said anything because I thought it was always my fault," as she told you from the witness stand. But I remember screaming, "No, no, I can't, Nikki. This is truly bringing me to tears and freaking me out." What's Nicole's very first response? "I do remember. I do remember." This happened, ladies and gentlemen. Nicole Edwards' response to her is independent evidence from the testimony of Jane Doe 4 that shows he's guilty of what he had done. I hated that we never said anything. I'm so glad they finally got him. Jane Doe 4, you have no idea the feelings I'm having right now. Isn't that real? Isn't that true? Isn't that a genuine and honest response to saying that a man who had raped you when you were a teenager in high school, when he rapes again, the feelings that Jane Doe 4 was having right then, the blame she may have felt because he did it again to another woman, that's real. And that hurts. And you saw that play out. And you saw that authentic reaction that she had to come forward because she had information about what he'd done in the past. And then you also heard from Brandon Guillermo and her husband with vague details, but the circumstances under which she told them that a man named Kellen had raped her, had sexually assaulted her, those all make sense too, right? One, she's having nightmares when asleep in bed with her live-in boyfriend, and she awakes, and he's saying, "What's wrong? What's wrong?" And she tells him. That's nearly a year afterwards. And then years later, with her husband, they're talking about prior experiences, and she tells him, "No, I was raped. I was assaulted by a guy named Kellen." Ladies and gentlemen, all of that predated any outside information about other acts by the defendant. And all of that is independent evidence that corroborates Jane Doe number 4. But not only does that corroborate Jane Doe 4, but the identity of the assailant itself is conclusively proven with the photograph that she has. And maybe you thought initially, that's kind of strange. Why would you keep that? Wouldn't you want to get rid of that and purge that from your memory? Well, what else rings true about what she said? I wanted a reminder that even when you feel safe, anyone can hurt you. And it was because of my daughters that I wanted to be able to get justice for these other women, to teach them to speak up when you've been harmed. Now, I told you how other evidence is not required in a sex offense according to the law, right? The testimony of a complaining witness alone is enough. But you also have the other crimes evidence, the predisposition and the propensity. So the fact that this happened with Jane Doe 4, as well as it happening with Jane Does 1, 2, and 3, that's all propensity evidence. It shows that he is inclined and willing to commit these types of offenses. But as it relates to Jane Doe 4, there's a special allegation that the court read to you yesterday. It's going to be contained on the same verdict form. Jane Doe 4, if you find him guilty of the forcible rape and the rape of an unconscious woman, once you've found him guilty of that crime, and you write in guilty on the verdict form, there are two special allegations. The first is whether or not there is independent evidence that clearly and convincingly corroborates Jane Doe 4's testimony, right? And that's what I was just referring to. The prior statements to Nicole Edwards, to Brandon Guillermo, and to her husband Troy M., the photograph, and the other acts evidence. Independent evidence is defined as separate and apart from Jane Doe 4's testimony. So all the testimony from the other witnesses and her prior statements and the text messages to Nicole Edwards is separate and apart from her testimony. It may include evidence of the defendant's sexual misconduct against a separate victim. So if you find that he committed the crimes against Jane Doe 2 and Jane Doe 1, or even Jane Doe 3, you can find that that sexual misconduct is independent evidence that he committed the rape of Jane Doe number 4 back in 2003. That's what the law says, and that's what you're allowed to do in order to make sure that justice is had for every one of his victims. Now, it goes further, and it says that such sexual misconduct, if believed by you, may, on its own, standing alone, constitute independent evidence that corroborates the victim's allegation. So if counsel gets up here and they argue to you that, well, you can't really believe everything that Jane Doe 4 said, it's just an allegation. Well, maybe she said it before, but it's the same allegation that she's testifying to. That's not the state of the law. The law says that even the other acts evidence by itself is independent evidence of Jane Doe 4's rape. Clear and convincing evidence, it's a different standard of proof that the judge instructed you on. It's less than beyond a reasonable doubt, and it's more than a preponderant standard, which simply means more likely than not. Ladies and gentlemen, Jane Doe 4's rape has been proven beyond a reasonable doubt, and there is independent evidence that clearly and convincingly corroborates the allegation. All of the other acts, all of the prior statements, the photograph that was provided in the text messages that were read into evidence confirms and corroborates that. That special allegation only applies to Jane Doe 4, all right? But there's an additional allegation that applies to Jane Doe 4 as well as Jane Doe's 1 and 2. It's an important allegation, and I labeled it the multiple victims allegation. That's the way the instruction reads. If you find the defendant guilty of 2 or more sex offenses, whether they be against Jane Doe 1 or 2 or 4, 2 or more sex offenses, as charging counts 2, 3, 4, 5, or 7. That would be the forcible rape of Jane Doe 1, the forcible oral copulation of Jane Doe 1, the forcible rape of Jane Doe 2, the forcible sodomy of Jane Doe 2, and lastly, the forcible rape of Jane Doe 4. If you find him guilty of 2 or more of those offenses, you must then decide whether we have proven the additional allegation that those crimes were committed against more than one victim in this case. This is the easiest legal instruction you've received. If you find beyond a reasonable doubt that he committed more than one forcible sex crime against more than one victim, then it's true. And you should fill it out accordingly. And then we turn to Jane Doe 5. Jane Doe 5 is a woman who, maybe we all have our favorites in terms of all these people that have come in to testify, but she's a woman that literally had no dog in this fight. She has no interest in the outcome of this case whatsoever. She's not motivated by anything other than coming to court and telling the truth. And what did she tell you time and time again? She didn't want to come forward. Her husband made her. She was afraid. She was trembling. She even said she was petrified by this man. Not a man that she had seen on the news, this man who was doing what he did to her at the gym, who asked her, after stroking his penis right next to her, waiting until she was on an exercise machine right next to him, stroking his penis and pushing it in her direction and asking her, do you see that? Do you like that? Is that not consistent with what he had done with Jane Doe 3 when he removed his penis from his bicycle shorts, standing there erect and holding it and smiling at her? You see that? You like that? That's what this defendant did. That is the extent of his sexual perversion. Lewd conduct in public. Lewd conduct in public can encompass a broad range of actual sexual conduct, right? Did the defendant, according to the first element, willfully engage in the touching of his own genitals? You have two separate incidents. You have the one where she unmistakably said he was touching and rubbing, stroking his penis as he sat next to her. And then you have the other incident where he gets into the jacuzzi with nothing on other than a tiny towel that's used to wipe down the equipment, and he sits right down next to her in an 8-person jacuzzi, and he begins moving his arm underneath the water. And as she described, and as you saw, he's masturbating. Yes, there's froth on the water. Yes, there's bubbles. Yes, she didn't actually see his penis. But who would look? And as you'll see, you don't have to see the penis. You don't have to actually see the exposed genitals for him to be guilty of lewd act in public. The defendant did so with the intent to sexually arouse or gratify himself or another person, or to annoy or offend another person. A very similar element to the indecent exposure count with Jane Doe 3. Almost identical. And that's getting into the mind of the sexual deviant, of the person who actually committed the act. What was his intent at the time? Was he trying to sexually arouse himself as he's stroking his penis and gaining an erection? Of course. Was he gratifying himself? Yes. But he was also annoying or offending another person. So he's guilty, according to that element. Was he in a public place? Of course. He's in an open gymnasium. Was someone else who might have been offended, were they present? Jane Doe number 5 described that she was. And did the defendant know, or reasonably should he have known, that another person who might have been offended was present? He sat down right next to her. He waited till she came on the exercise machine, and he began stroking himself. And then he stands in front of her, facing her, locking eyes with her, asking her, do you see this? Do you like that? That's a lewd act in public. When he gets into the jacuzzi, he walks out of the locker room, he gets a drink of water, he looks directly at her. Is she making that up? Is she lying about that? He targets her. He identifies her. He recognizes her. He walks out with his bathing suit in his hand, puts it on top of his backpack, wearing nothing but the towel, and he acts again, consistent with what he had done before. He knew that she was present, and he knew that she would be offended by it. Elder abuse and elder battery, the additional counts as it relates to Jane Doe number 5. We're almost done. Jane Doe number 5 is a victim of elder abuse. And maybe not in the way that you might think of it or you see it on TV. It's not a theft, it's not physical pain, but she is a victim of elder abuse according to the law. The defendant, the first element, willfully inflicted unjustifiable physical pain or mental suffering on Jane Doe 5. Did the defendant inflict mental suffering on Jane Doe 5? You saw her demeanor in court. You saw how upset and irate and offended and hurt she was. You heard the descriptions from the gym managers. You heard the descriptions from the initial responding officer. She was still trembling. She was still petrified and afraid. That's mental suffering under the law. Was she an elder? Yes, because the law says it's anyone 65 or older and she's 77. When the defendant acted, he knew or reasonably should have known that she was an elder. As I said, you saw her. She's certainly over the age of 65. She's pushing 80. And the defendant still targeted her. Unjustifiable mental suffering is pain or suffering that is not reasonably necessary or is excessive under the circumstances. It's certainly excessive when a woman's just trying to go about her daily routine. 3 days a week, Monday, Wednesday, Friday, same time, every time, right? When this man decides to target her, not just once, but twice. And that under those circumstances, she should not have been subjected to anything, let alone the mental suffering that he inflicted upon her. Elder battery, similar to elder abuse in the last two elements, but the first element just requires that the defendant touched her in a harmful or offensive manner. Under those circumstances, in that jacuzzi, when he made physical contact by grabbing / touching / what is this when you put your hand around your arm on the elbow, as she said repeatedly, that's a grab, right? When he touched her in that offensive way, right as he had just been masturbating next to her, that's a battery. The slightest touching can be enough to commit a battery if it's done in a rude or angry way. Oh, certainly it's been done rudely. Making contact with another person is enough in itself. The touching does not have to cause pain or injury of any kind. So, Jane Doe number 5 is the defendant's last, most recent victim. She's a victim of multiple lewd acts, elder abuse, and elder battery. And there's been no evidence to dispute that. So you have to be asking yourself, God, what are they going to say? What's their theory of the case? How are they going to be able to overcome what happened here? All of this information, all of these women. And really, it comes down to this. Well, you can't believe all 5 of them, right? The presumption of innocence attaches, it exists, all the way through into your deliberations. But once you've all gotten together, decided the facts, and applied the law, you can overcome that presumption of innocence by the mountain of evidence that's been presented. It's not 1, it's not 2, but 3 women who've been raped. 5 women who were victimized by this man. But they would ask you to not believe in any of them, or let alone all of them. Do you think that this was no strings attached consensual sex? There's no such evidence that's been presented to you to suggest that, to support that. But they're going to try to ask you to use the presumption of innocence to somehow poke holes, right? But when they try to poke those holes, none of it actually impacts the core facts of what happened. The peripheral, extraneous, things that the law instructs you that you get to decide whether they're important or not. So reject that argument. Who's heard the phrase of buyer's remorse? Is that what this is? Well, I was interested in him at the beginning of the night, and then the next night I had that feeling of maybe I shouldn't have done what I did. There's no evidence whatsoever that that's what happened. Each one of these victims has said consistently that they were threatened, that they were afraid, that they were going to be killed. Jane Doe's 1 and 2. Jane Doe 4, that when she regained consciousness, he was forcibly raping her. Jane Doe 3, she didn't know who had done this, but she was certainly upset and offended by it. And Jane Doe 5, again, didn't know until she and her husband got together afterwards, and in a conversation with the managers, they figured it out. But before that, she had no idea who had done this. Just a man who targeted her while she was at the gym. There is no motive that's been established for any one of these victims. Even when they have made that lame attempt to call back Summer Foster, you say, well, did you create a GoFundMe account? Is this the one that you created? Yes. Did you ask for $50,000? Yes. Why? Notice they didn't ask that. I needed to help my mother. I wanted her to be able to get away from where this had happened to her, to get away from the man that raped her. Ladies and gentlemen, there's been no motive established. Notice also that not a single shred of evidence suggests that any one of these women is after the defendant for his money. There's been no evidence presented about that because it's not true. ladies and gentlemen, reject these defense theories. What is their theory on Jane Doe 3? It wasn't me. In opening statement, Mr. Watkins stood up and said, Jane Doe 3 is not going to accuse Mr. Winslow of anything. She doesn't have to. We've proven that it was him. We've proven that he did this. We've proven that he was there that day. Ladies and gentlemen, what's the theory that they have? Jane Doe 4, to go through the hell that she did by coming forward and talking about what he'd done. What motivates her? Are they going to argue that because she consented 2 weeks prior to sex, that means that she had to have consented the second time? How does that make sense when she described that the first consensual act where they were kissing, they were being amorous, they had been flirtatious earlier, that ended abruptly when she put a stop to things? When the same person, Matt, came into the room and she stopped Mr. Winslow. Was she going to consent the next time when Matt was in the room? When perhaps even others were filming it? Was she going to consent? That's what they'd like you to believe, but that's not what's been proven through the course of the evidence. There's no evidence to support that theory. She has told you that she stopped things the first time, and she told you that she did not consent the second time. So that's what it amounts to, right? They must all be liars. Every single one of them. Every woman that you listened to over the last 2 weeks, they must be lying to you, and they must be incredible actresses as well. Can't believe anything that they've said, or at least maybe not some of these things on the periphery, so then you shouldn't believe any of the other stuff, right? Come on, ladies and gentlemen, use your common sense. Reject that theory because it's unreasonable. It is completely unreasonable to believe that every single one of these women has come to court and gone through what they've gone through to tell their story for a lie. And how do they possibly explain Jane Doe 5? They're going to call her a liar? Or maybe she was just so mistaken about what he was doing when he thrust his erect penis in her face saying, do you see that? Do you like that? It was just a huge misunderstanding, right? This case is not a he said, she said. Reject that theory too. How could this case possibly be a he said, she said? This case is a she said, and she said, and she said, and she said, and she said. 5 separate women, 5 separate victims, all of whom have been confirmed and corroborated by each other. This man is a sexual predator who acted and victimized against every single one of these women. You as jurors have a duty to reject the defense theories because they're unreasonable. You have a duty to render true and just verdicts based upon the reasonable assessment of the evidence. The court told you that direct evidence can prove a fact by itself. The testimony of a witness is direct evidence. Circumstantial evidence is evidence of another fact from which you may logically and reasonably conclude the truth of the fact in question. All of the other acts is circumstantial evidence that corroborates and confirms the truth of what the direct testimony was from each victim. Both are acceptable and reliable to prove elements of a charge. And the court instructed you, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. And that's why you have the duty to be reasonable and the duty to reject the defense theories, because they are unreasonable. Every single one of counts 1 through 12, the charges, have been proven beyond a reasonable doubt. You, every single one of you, have the awesome authority and privilege to be able to render a guilty verdict and give justice to Jane Doe 1, Jane Doe 3, and Jane Doe 5, to show that they were victims of the crimes that are alleged related to each of them. Give justice to Jane Doe 1 and 2. The evidence is proven beyond a reasonable doubt that he committed both of these forcible rapes against each of these women. That he kidnapped Jane Doe 1 in order to commit rape and oral copulation. That she withdrew her consent, that he threatened her. Find him guilty of all of those crimes for Jane Doe's 1 and 2. And lastly, give Jane Doe 4 justice. It may be delayed, but give her justice because the evidence has proven beyond a reasonable doubt that he raped her in 2003. Thank you, Your Honor.
All right, thank you. Mr. Carlos?
An hour at least, you think? That's up to the, I guess, the jury.
You want to start now and break it up? So you do.
I don't want to break up, so I'd rather.
I'm sorry?
I don't want to break anything up. I'd rather go straight.
You want to go straight through for an hour? Okay. Do you want to break for lunch now and come back at 1? Or do you want to go straight through to 12:30? I see no hands being raised. So why don't we do this? Why don't we go ahead and take our break now? We will come back at 1, and we'll start up at 1 o'clock, and you can go straight through. How's that, Mr. Carlos?
It's fine, man. That's up to the jury, Your Honor. I can do either.
Okay. Well, we've sat through an hour and a half, so why don't we go ahead and do that? Mr. Owens, you know how long your rebuttal will be?
Depends on how long this goes.
Okay. So we'll go ahead and do that. We'll go ahead and take our break now. So we'll come back early. We'll come back at 1 o'clock, and we'll see everybody back here at 1. Please remember the admonition. Don't discuss the case with anybody or form or express any opinions. We'll see you back here at 1 o'clock. We're in recess.